ನಮಸ್ಕಾರ, ನಾನು ಸಂಗೀತಾ ನಂಜುಂಡಸ್ವಾಮಿ. ಇವತ್ತು ನಾನು ನಿಮ್ಮಲ್ಲಿ ಒಂದು ಮನವಿ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ದಿ ಫೈಲ್ ಕಳೆದ 3 ವರ್ಷಗಳಿಂದ ಯಾರ ಮುಲಾಜಿಗೂ ಒಳಗಾಗದೆ ನಿಷ್ಪಕ್ಷಪಾತವಾಗಿ ತನಿಖಾ ವರದಿಗಳನ್ನು ನಿಮ್ಮ ಮುಂದೆ ಇಡ್ತಾ ಇದೆ. ಕೋವಿಡ್ ಹಗರಣ ಆಗಿರ್ಬೋದು, ಶಿಕ್ಷಕರ ನೇಮಕಾತಿಯಲ್ಲಿನ ಅಕ್ರಮವಾಗಿರ್ಬೋದು, ಸರ್ಕಾರದ ಹಲವಾರು ಭ್ರಷ್ಟಾಚಾರಗಳನ್ನು ದಾಖಲೆ ಸಮೇತ ಬಯಲು ಮಾಡ್ತಾ ಇದೆ. ನಮ್ಮ ಈ ವರದಿಗಳನ್ನು ಆಧರಿಸಿ ತನಿಖಾ ಆಯೋಗಗಳು ರಚನೆ ಆಗಿದೆ. ನಮ್ಮ ಸಂಸ್ಥೆ ಹೀಗೆ ನಿರಂತರವಾಗಿ ನಿರ್ಭೀತಿಯಿಂದ ಸ್ವತಂತ್ರವಾಗಿ ಮುಂದುವರಿಯೋದಕ್ಕೆ ನಿಮ್ಮ ಸಹಾಯ ಅತ್ಯಗತ್ಯ. ಹಾಗಾಗಿ ನನ್ನ ಮನವಿ, ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಬಾಕ್ಸ್ನಲ್ಲಿರುವಂಥ ಲಿಂಕ್ ಬಳಸಿ ಅಥವಾ ಈ ವಿಡಿಯೋದಲ್ಲಿ ಕೊನೆಗೆ ಬರುವಂಥ QR ಕೋಡ್ನ ಸ್ಕ್ಯಾನ್ ಮಾಡಿ ನಿಮ್ಮ ಕೈಲಾದಷ್ಟು ಹಣ ಡೊನೇಟ್ ಮಾಡಿ. ಈ ಮೂಲಕ ಸ್ವತಂತ್ರ ಪತ್ರಿಕೋದ್ಯಮವನ್ನು ಬೆಂಬಲಿಸಿ. ನಮಸ್ಕಾರ. ನಮಸ್ಕಾರ, ನಾನು ಸಂಗೀತಾ ನಂಜುಂಡಸ್ವಾಮಿ. ಇವತ್ತಿನ ವಿಶೇಷ ಆನ್ ದ ರೆಕಾರ್ಡ್ನಲ್ಲಿ ನನ್ನನ್ನು ಜಾಯ್ನ್ ಆಗ್ತಾ ಇದ್ದಾರೆ. ಕರ್ನಾಟಕದ ಅಂತಾರಾಜ್ಯ ಜಲ ವಿವಾದಗಳಲ್ಲಿ ಕರ್ನಾಟಕವನ್ನು ಪ್ರತಿನಿಧಿಸುವಂಥ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನ ಹಿರಿಯ ವಕೀಲರಾಗಿರೋ ಶ್ರೀ ಮೋಹನ್ ವಿ ಕಾತರ್ಕಿ ಅವರು. ಸರ್ ನಮಸ್ಕಾರ. ಸರ್ ಹೇಗಿದ್ದೀರಾ ಸರ್? ಗುಡ್ ಸರ್, ಥ್ಯಾಂಕ್ ಯು. ಸೊ ಇನ್ಸಿಡೆಂಟ್ಲಿ ಯು ಆರ್ ಇನ್ ಕರ್ನಾಟಕ ಡ್ಯೂರಿಂಗ್ ಇದು ಬರ್ನಿಂಗ್ ಇಶ್ಯೂ, ಲಿಟ್ರಲಿ ಬರ್ನಿಂಗ್ ಇಶ್ಯೂ ಆಫ್ ಕರ್ನಾಟಕ, ಕಾವೇರಿ ವಿವಾದ. ಈ ಸಮಯದಲ್ಲಿ ನೀವು ನನಗೆ ಸಮಯ ಕೊಟ್ಟಿದ್ದೀರಾ. ಫಸ್ಟ್ಲಿ ಐ ಥ್ಯಾಂಕ್ ಯು. ಆದರೆ ಈ ವಿಷಯಕ್ಕೆ ಬಂದಾಗ ಇದು ಡಿಕೇಡ್ಸ್ ಓಲ್ಡ್ ಅಲ್ಲ, ಸೆಂಚುರಿ ಓಲ್ಡ್ ಆಗಿರುವಂಥ ವಿವಾದ. ಪ್ರತಿ ಸಲವೂ ಕರ್ನಾಟಕದ ಜನತೆಗೆ ನಮಗೆ ಅನ್ಯಾಯ ಆಗಿದೆ ಅನ್ನುವಂಥ ಭಾವನೆ ಮೂಡ್ತಾ ಹೋಗುತ್ತೆ. ನಾವಿದ್ರದ ಕ್ರೊನಾಲಜಿ ನೋಡೋದಾದರೆ ಪ್ರೀ ಇಂಡಿಪೆಂಡೆನ್ಸ್ ಅಂದರೆ ಬ್ರಿಟಿಷ್ ಇಂಡಿಯಾದ ಕ್ರೊನಾಲಜಿ, ಅಲ್ಲಿ ಆದಂಥ 2 ಅಗ್ರಿಮೆಂಟ್ ಬಗ್ಗೆ ಮಾತಾಡ್ತಾ ಶುರು ಮಾಡೋಣ ಸರ್.
Sure.
2 agreements that happened during British India. ಯಾವಾಗ ಮದ್ರಾಸ್ ಪ್ರೆಸಿಡೆನ್ಸಿ ಆ್ಯಂಡ್ ಮೈಸೂರು ಸಂಸ್ಥಾನದ ನಡುವಿನ 2 ಒಪ್ಪಂದದ ಬಗ್ಗೆ ನೀವು ಹೇಳೋದಾದರೆ.
1799ನಲ್ಲಿ ದಿ ಮೈಸೂರು ಟೆರಿಟರಿ ಆಫ್ಟರ್ ದ ಫಾಲ್ ಆಫ್ ಟಿಪ್ಪು, ಅಂದರೆ ಆಂಗ್ಲೋ ಮೈಸೂರು ವಾರ್ ಏನಾಯಿತು, fourth war, the British took over the territory of Mysore and they decided to return it to the old Wadiyar royal family. And family was installed into the power, but with terms and conditions called subsidiary alliance agreement.
Okay.
So our agreement talage Mysore was supposed to be a vassal state of the British crown in England. ಆಮೇಲೆ ಅವ್ರೇನು ಅಡ್ವೈಸ್ ಕೊಡ್ತಾರೆ, ಅವ್ರು ಏನು ಹೇಳ್ತಾರೆ ಅದನ್ನೆಲ್ಲ ಅವ್ರು ಪಾಲಿಸ್ಬೇಕಾಗಿತ್ತು. ಅಷ್ಟೇ ಅಲ್ಲ, ಮೈಸೂರು ಗೌರ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಪೇ ಟ್ರಿಬ್ಯೂಟ್ ಟು ದಿ ಬ್ರಿಟಿಷ್ ಗೌರ್ಮೆಂಟ್. ಮುಂದೆ ಮೈಸೂರು ಸರ್ಕಾರಕ್ಕೆ ಯಾವುದೋ ಒಂದು ಆರ್ಮಿ ಅಥವಾ ಇಂಡಿಪೆಂಡೆಂಟ್ ಫೋರ್ಸ್ ರೇಸ್ ಮಾಡೋ ಅಧಿಕಾರ ಇರಲಿಲ್ಲ. ಸೊ ಅವರಿಗೆ ಒಂದು ನಮೂನಿ ಪವರ್ಲೆಸ್
ಅಟಾನಮಿ
ಇಲ್ಲ, ಪವರ್ಲೆಸ್ ಕಿಂಗ್ ಮಾಡಿ ಕುಂಡಿಸಿದ್ರು. ಆ್ಯಂಡ್ ದೇ ಅಲಾಟ್ ದೆಮ್ ಟು ರನ್ ದ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್. ಮುಂದೆ by 1830 there was a problem. They superseded the administration by citing the clause in the 1799 Subsidiary Alliance Treaty that there is a misrule in the administration. So we will supersede the administration and impose the rule of commissioner of the East India Company. Okay. This is like today's president rule, you can say. And that commissioner rule lasted for 50 years, as we all know. During that period, very eminent commissioners, of course, ruled Mysore, including Kaban. Then finally, Mysore royal family succeeded in convincing the British government to restore their administration and remove the commissioner rule. So, 1862ದಲ್ಲಿ ಅದನ್ನು ರೆಕಗ್ನೈಸ್ ಮಾಡಿದ್ರು. ಫೈನಲಿ 1882 ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಆಫ್ ದಿ ಟ್ರಾನ್ಸ್ಫರ್ ಪವರ್ ಅಂತಾರೆ, ಅದರ ಪ್ರಕಾರ they retained the power, but again with all the conditions which were there in the 1799, that is subsidiary alliance treaty, under which hands and legs of Maharaja were tied, and he was mainly a figurehead under the British. This is how the administration came. ಈ ಟೈಮ್ನಲ್ಲಿ ಏನಾಯ್ತಪ್ಪ ಅಂತಂದರೆ, there was very interesting developments took place. Way back in 1807, Madras government, that is the collector of Tanjore, raised some objections to the irrigation works taken up by the Mysore
ಮೈಸೂರು
government.
ಪ್ರೆಸಿಡೆನ್ಸಿ ಮೈಸೂರು
The,
ಸಂಸ್ಥಾನ.
Mysore government. They said that you have taken up a lot of irrigation works, and because of that, there is a diminution of flow in the Tanjavur, and therefore you are requested to stop. ಆ ಕಂಪ್ಲೇಂಟ್ ಸೀರಿಯಸ್ ತಗೊಂಡ್ರು. ಅವಾಗ ಬ್ರಿಟಿಷ್ ರೆಸಿಡೆಂಟ್ ಏನಿದ್ರು ಮೈಸೂರಲ್ಲಿ, ಅವ್ರು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿದರು. ಮಾಡಿ ಅದಕ್ಕೆ ಉತ್ತರ ಕೊಟ್ಟರು. 3 ವರ್ಷ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿ, we have gone through everything, and according to us, none of the works which are in Mysore now taken up have caused any diminution of flows in Tanjavur, what you are getting, because ನಾವೇನು ಕೆಲಸ ತಗೊಂಡಿದ್ದೇವೆ, it is basically restoration of tanks which were there for a long time, but for some reasons they were not under use for decades. ಸೊ ಇವೆಲ್ಲ ಆನ್ಸಿಯಂಟ್ ಟ್ಯಾಂಕ್ಸು, ಅವನ್ನ ರಿಸ್ಟೋರ್ ಮಾಡಕತ್ತೀವಿ. ಇದರಿಂದ ನಿಮಗೆ ಏನಾಗಬಾರ್ದು, ಮೊದಲು ಆಗಿರಲಿಲ್ಲ ಅಂದರೆ ಈಗ ಹೆಂಗಾಗುತ್ತೆ, ಸೊ ನಿಮ್ಮ ಕಂಪ್ಲೇಂಟ್ನಲ್ಲಿ ಏನು ಒಂದು ಅರ್ಥ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು. ಅದಾದಮೇಲೆ ಮೈಸೂರು ಬಗ್ಗೆ ತಂಜಾವೂರು ಏನು ಹೇಳಿಲ್ಲ, ಸುಮ್ಮ ಕೂತ್ಕೊಂಡ್ರು. ಮುಂದೆ 1862ದಲ್ಲಿ ಒಂದು ಕಮಿಷನರ್ ಗೌರ್ಮೆಂಟ್ ಏನಿತ್ತಲ್ಲ, ಒಂದು ರಿಪೋರ್ಟ್ ಮಾಡಿದರು, ಸ್ಯಾಂಕಿ ರಿಪೋರ್ಟ್. ಅದು ಚೀಫ್ ಇಂಜಿನಿಯರ್ ಇನ್ ಹೂಸ್ ನೇಮ್ ದ ಸ್ಯಾಂಕಿ ರೋಡ್ ಈಸ್ ನೇಮ್ಡ್. ಸೊ ಹಿ ಪ್ರಿಪೇರ್ಡ್ ಎ ರಿಪೋರ್ಟ್ ಫಾರ್ ರಿಸ್ಟೋರೇಷನ್ ಆಫ್ 30,000 ಟ್ಯಾಂಕ್ಸ್ ಇನ್ ಮೈಸೂರು ಅಗೇನ್. And that report of Sankey received its approval by the Secretary of State in London.
Okay.
And it was about to be implemented. Then the objection came from again Tanjavur, Madras government, that what is this, you are implementing something, and this will cause reduction of flows, and Tanjavur farmers will suffer, Delta will suffer. ಇದೆಲ್ಲ ನೀರು ನಮಗೆ ಬರಬೇಕು as per the customary rights, as per the prescriptive rights, historical rights ಅಂತ ಹೇಳಿ they argued. And for some reason the scheme was not taken up, though it was approved by the Secretary of State in London. It was not taken up. In the meanwhile, power was transferred back to the Maharaja of
Odear family.
So hೀಗಾಗಿ ಒಂದು 10-15 years that report of Sankey remained unimplemented, though it was approved by the Secretary of State. So 1880 ಒಳಗೆ, when Mysore decided to take up, the Sheshadrayar had just become the Diwan, not 1889-90 ಒಳಗೆ. Then again this question came up, whether Mysore can take up, whether Mysore can do things which will
benefit,
which will help Mysore to develop irrigation without affecting the traditional irrigation in Tanjavur ಅಂತ ಹೇಳಿ. So a lot of discussion took place in Ooty. ಮೈಸೂರು ಹೇಳಿದರು, ನೋಡ್ರಿ, ನಮ್ಮ ಪ್ರಕಾರ, they talked very illegally in those days. We have all rights to the waters that is in the territory of Mysore, except the water required for farmers in Tanjavur. So ಕನ್ಸಿಡ್ ಮಾಡಿದ್ರು, ನಿಮ್ಮ ವಾಟರ್ ಎಷ್ಟಿದೆ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ, ಬಟ್ ಅದಾದ್ಮೇಲೆ ವಾಟ್ ಎವರ್ ಇಸ್ ದೇರ್, ಹೆಚ್ಚುವರಿ ವಾಟರ್ ಆಲ್ ಬಿಲಾಂಗ್ಸ್ ಟು ಅಸ್. ಸೊ ಅದ ಮೇಲೆ ಒಂದು ಲೆಕ್ಕನ ಕೊಟ್ಟರು, ಬಟ್ ದೇ ಡಿಂಟ್ ಅಗ್ರಿ, Tanjavur people, that is Madras. They said you can't calculate like that. We have a right over the entire natural flow. ಅಂದರೆ ನೀರು ಹೇಗೆ ಒಂದು ನೇಚರ್ನಲ್ಲಿ ಹರಿಯುತ್ತದೆ, ಸೊ ಅದ್ರ ಮೇಲೆ ನಮಗೆ ಹಕ್ಕಿದೆ. ಸೊ ದೇ ಇನ್ವೋಕ್ಡ್ ದಿ ನ್ಯಾಚುರಲ್ ಫ್ಲೋ ಥಿಯರಿ, which was also invoked by several countries in the Europe in earlier. So they invoked that natural flow theory, and after that there was a lot of discussion. Finally an agreement was entered into in 1892, which said that the state of Mysore can construct any project, provided it will not affect the prescriptive right of Madras. On the face of it, this appeared a good agreement.
Fair.
But there was a problem. What are the prescriptive rights of Madras? Madras will decide. So it was sort of a veto power given to Madras. It has to decide what are its prescriptive rights.
ಸರ್, ಇದಾಗೋದಕ್ಕೆ ಕಾರಣ ಮೈಸೂರು ಸಂಸ್ಥಾನವಾಗಿತ್ತು, ಡೈರೆಕ್ಟಾಗಿ ಮದ್ರಾಸ್ ಬ್ರಿಟಿಷ್ ರೂಲಿಂಗ್ನ ಕೆಳಗಿತ್ತು.
Yeah.
ಇದೇ ರೀಸನ್ ಇಂದ
Yeah,
ಇದಾಗೋದಕ್ಕೆ
it
ಕಾರಣ.
is one of the reason because people said, look here, Mysore is the princely state, and though British are the warlords of the Mysore, but they don't have direct responsibility. Whereas in case of Madras, it is their territory, British territory. They have responsibility to the people, and therefore they are trying to assert their rights better, and at the cost of the Mysore. So the an impression got developed in Mysore that they are treating us like a step,
ಸೆಕೆಂಡರಿ ಸಿಟಿಸನ್ಸ್.
yeah, second class citizens.
Second class citizens.
Though overall it is a part of the British Empire, but princely states were treated as the second class citizens, and those in the British territory were treated as the better citizens. So that is how the problem started, and what agreement was entered into in 1892.
ಓಕೆ. ಸೊ ಆ ಟೈಮ್ನಲ್ಲಿ ಈ ರೀಡ್ ಬಿಟ್ವೀನ್ ದ ಲೈನ್ಸ್ ಮೈಸೂರು ಸಂಸ್ಥಾನವನ್ನು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಿರುವಂಥ ವಕೀಲರು ಮಾಡಿರ್ಲಿಲ್ವಾ ಅಥವಾ?
We don't have any records actually. We try to search in the archives and all.
Okay.
But surely the best legal brains went into the matter. And if we read those letters and all, so well drafted, and I'm sure that best of the legal minds available then were consulted by the Mysore government as well as the Madras government.
ಓಕೆ. ಸೊ ದೆನ್ ಕಮ್ಸ್ ದ 1924 ಅಗ್ರಿಮೆಂಟ್. ಅಲ್ಲಿ ಯಾವ ಬದಲಾವಣೆಗಳಾಯಿತು, ಏನನ್ನು ಉಳಿಸ್ಕೊಳ್ಳಾಯಿತು, ಏನ ಅಡಿಷನ್ ಆಗಿ ಮಾಡ್ಕೊಳ್ಳಾಯಿತು?
See, 24 agreement ಇದು ಒಂದು 1892 agreement ಕೆಳಗಡೆ ಬಂತು. 1892ದಲ್ಲಿ ಏನು ಹೇಳಿದ್ರು, ಮೈಸೂರು ಕ್ಯಾನ್ ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಎನಿ ಪ್ರಾಜೆಕ್ಟ್ provided it does not hurt or injure the prescriptive rights of Madras.
Okay.
And Madras will decide.
Correct.
And if you are unhappy, you go to arbitration.
Okay.
That is how the scheme of the agreement of 1892. So we proposed KRS in early part of the 20th century. Then there was some problem, financial problems. Then it was not pursued further. Then Vishesharaya came to Mysore after taking a retirement in the Bombay presidency, where he retired as the superintending engineer. Here he was appointed by the Maharaja as the chief engineer.
Chief engineer.
So Vishesharaya had his entire career served in the Bombay presidency, and after retirement he became a chief engineer here. As soon as he became a chief engineer, first thing he did was that, look here, you people have planned something called Kannambadi, and primarily you planned it to supply, to generate electricity at Shivanasamudram, to supply that electricity to the Kolar goldfield. Fine, but I would think that it should be a larger dam, and if you construct a larger dam, these financial implications which you are thinking can be overcome. And I have the experience in Pune district in Bombay presidency, and many other places also in those days, that the whatever expenditure the government incurs, it can recover in the form of a revenue by growing, by helping the farmers to grow better crops. So Maharaja was convinced about the proposal. Then he said, very good, then you send the proposal to Madras and negotiate and get their consent. Very good. He appears to be very attractive. Then Vishesharaya very religiously negotiated the matter with the Madras. And there was one great engineer in Madras also. I can't recall his name. Elliot or something. And he was also equally great. And both of them really sat together continuously, meeting almost every second month, either in Madras or in Mysore, try to sort out the issue. How can Mysore construct a project for 44 TMC, which not only serves as a backup reservoir for production of electricity at Shivanasamudram, but also store more water and irrigate the lands. So ಅದರ ಬಗ್ಗೆ ಒಂದು ಡಿಸ್ಕಷನ್ ಆಗಿ ರೂಲ್ಸ್ ಹೇಗೆ ಮಾಡಬೇಕು, ಹೇಗೆ ಮಾಡಿದರೆ ತಂಜಾವೂರು ಫಾರ್ಮರ್ಸ್ದು ಅಫೆಕ್ಟ್ ಆಗಂಗಿಲ್ಲ, ಇಲ್ಲಿ ಮೈಸೂರಿಗೂ ಒಂದು ಅದಕ್ಕೆ ಇದು ಸಿಗ್ತದೆ, ಕಟ್ಟಲಿಕ್ಕೆ ನೀರು ಸಿಗ್ತದೆ, ಒಂದು ನಮಗೂ ಒಂದು ಇದು ಆಗ್ತದೆ. ಸೊ ದೇ ಫೈನಲಿ ವೇರ್ ಏಬಲ್ ಟು come to some kind of understanding, but it didn't work out
Okay.
at the government level.
Okay.
Then the Madras government said, no, we'll grant consent only for 11 TMC.
Uh-huh.
So that was a very setback for the Mysore. But Vishwesvaraya advised the government, that is the Maharaja, well, we'll go to arbitration. Now arbitration, we have got a very good case. We'll definitely win. And therefore, we'll lay the foundation for a 44 TMC.
TMC.
No difficulty. I'm quite sure we're going to succeed in the arbitration.
Hmm.
So that's how money was spent to lay the foundation stone for the 44 TMC, a larger dam. But said that if you don't succeed, we'll limit it to 11 TMC.
Okay.
So that's how Vishwesvaraya proceeded. So matter went to arbitration. One justice, English judge called Justice Griffins of Allahabad High Court was appointed as the arbitrator, and he almost continuously conducted the arbitration for 11 months. He was assisted by the then Inspector General of Irrigation in India. That post was there when India was a unitary system. It is presently federal. The irrigation is not the central subject. In those days, it was. So there was the Inspector General of Irrigation. So one retired Inspector General of Irrigation was appointed as the assessor
Okay.
to assist the judge.
Okay.
So the proceedings were held for nearly about a year in Ooty, and the Mysore had engaged lawyers. The other side also had engaged lawyers, technical people. So they submitted a report, arbitrator, upholding the claim of Mysore for 44 TMC.
Okay.
No, but he imposed certain restrictions, severe restrictions. Mysore was okay with that.
Okay.
And we were happy that we were able to succeed in getting a permission to construct 44 TMC dam.
ಏನ್ ರೆಸ್ಟ್ರಿಕ್ಷನ್ಸ್ ಆಗಿತ್ತು ಸರ್ ಅದು ಯಾವೆಲ್ಲ
The
ರೆಸ್ಟ್ರಿಕ್ಷನ್ಸ್
nature of release is to be made from the dam,
ಓಕೆ
and so that the farmers in Tanjavur do not suffer. That was the condition. So the rules of regulation, ಯಾವಾಗ ನಾವು how to fill up a dam, first ಫ್ರೆಶಸ್ ಆಗಿ ಹಿಡಿಬೇಕು, ಹೇಗೆ ಬಿಟ್ಕೊಡ್ಬೇಕು, what is the proportion of holding and what is the proportion of outflow at the dam. So ಎಲ್ಲ ವರ್ಕೌಟ್ ಮಾಡಿ ಕೊಟ್ಟರು. So we're happy with that. But Tanjavur farmers are, Tanjavur is a very educated place. That is a place in those days considered to be the first place in the country where maximum graduates were found. Highest number of Indian civil service officers among the Indians were from Tanjavur. The entire Madras bar, eminent lawyers were from Tanjavur. You take any sector in India, either it was Bengali or it was Tanjavur farmers, Tanjavur people. So they were very concerned. And C.P. Ramasamy Iyer was one of the eminent lawyer, was a member of the Madras Executive Council. He took up the matter very seriously. Then they appealed to the Government of India. Government of India rejected their appeal, endorsed the arbitration award of Justice Griffiths.
Okay.
But even then, they filed a further appeal to the Secretary of State in London. And in those days, the Farmers Association collected a lot of funds. That's what it says, history. And they engaged the best lawyers possible and engineers also. And they went to the Secretary of State. And Mysore consulted on the top barrister in Calcutta, Mr. Brijendra Kumar Sen, to understand about the legality and all. We have the copy of his opinion also, taken in 1918 or something. So it finally decided that the Secretary of State, he issued a direction that prima facie I find there is an error in the order passed by the arbitrator. And therefore I direct the parties either to renegotiate and settle the matter
Okay.
or to agree for a fresh arbitration.
Okay.
So you have two options. Either you settle among yourself or agree for a fresh arbitration. So at that time, already Mysore had sunk a lot of money because we proceeded on a
ಡ್ಯಾಮ್
basis.
ಬಿಲ್ಡಿಂಗ್ ಶುರು
Building
ಆಗ್ಬಿಟ್ಟಿತ್ತು
ಆಗಿತ್ತು. And we proceeded on a basis that 44 TMC we should get, we are going to get, likely to get ಅಂತ ಹೇಳಿ. So further arbitration, ಇದೆಲ್ಲ ಸ್ವಲ್ಪ found it difficult. So our people preferred a negotiation. negotiation ಆಯಿತು. Somewhere in 1921, rules of regulations were approved
Okay.
by, agreed by both the chief engineers of the state.
Okay.
How KRS should be operated. Well, it should have stopped at that point, if you ask me. Okay, because the whole question was Mysore wants KRS and how to operate the reservoirs. It means how to release water down and how much to hold. So that rules of regulations of 1924, though it was all one-sided, it gave 80% of the water to the state of Madras, but it was still better. But they didn't agree for that. They said that this is only my prescriptive right.
Okay.
I want a share in the surplus water also.
ಅಡಿಷನಲ್ ಆಗಿ
Yes.
ಹೆಚ್ಚುವರಿ ನೀರು
Yeah.
ಇರುತ್ತೆ ಅದ್ರಲ್ಲಿ. ಹಾ.
Which Mysore said, well, this is all my water under the 1892 agreement. You have no share in that. Which Madras didn't agree. They said nothing doing. Unless we agree on sharing of surplus, we will not sign this, approve these rules of regulations. So matter got further delayed. As a result, negotiations took place. And negotiations finally led to a 1924 agreement, under which the rules of regulations which were approved in 1921 were approved
Okay.
at the government level.
Okay.
Then they decided to share the surplus water. So under surplus water, including the right of Madras to construct Mettur reservoir was approved. Then also because Mettur reservoir is essential for Madras to use the surplus water. The surplus water would have gone to sea otherwise. So they got Mysore that. They also got right to construct Bhavani reservoir. And we were given some rights. In case they construct Bhavani reservoir, I can construct some offset reservoir. That's how company was planned later. So these are the small things Mysore got. Even in the surplus water, the Madras got a lion's share. So that is how an injustice happened to the state of Mysore in those days. So Mysoreans always have that feeling that the people from Madras, who are known for their intelligence, known for their eloquence, were able to act smart, particularly by use of the British power. Their closeness to British power helped them to overrule us and walk away with large quantity of water. Feeling developed.
Okay.
But nevertheless, after the 1924 agreement, we went ahead and constructed our dam. They constructed Mettur. In between, there was some hiccup that calculation of the proportionate formula. We couldn't agree because there was surplus flow. There was a large flood in 1928. Again, matter went to arbitration of Justice Page of Calcutta High Court.
Okay.
The very eminent lawyers appeared. As the record shows, Mysore had engaged Mr. Chimanlal Settlewad from Bombay. The Madras had engaged Mr. Alladi Krishnaswamy. So the case was fought out, but finally the arbitration ended in a compromise. With the help of arbitrator, some kind of compromise was arrived at. So 0.62 was worked out as the proportionate formula.
Okay.
For the operation of the KRS.
Okay. 0.62 ಅಂದ್ರೆ
Yeah.
ಸರ್.
Andre, whatever water comes up to the KRS,
Okay.
62% should go down to Tamil Nadu. Up to KRS, roughly about 200 and we can say, 483, 80 here and another 120 there, 200 there, about 280 TMC water is available. Of that, I'm just roughly giving, 62% has to go to them, and that too precious. That means the minimum guaranteed flow is given to the state of Madras. It is only in the surplus which may occur, may not occur. The Mysore has to, may hold and irrigate under KRS.
Okay.
That's how it was conceived.
Okay.
It was a very arbitrary agreement, very onerous for us. Though we got little, even that little we got in the surplus water, not in the regular flow.
Regular flow.
And there was no distress formula because everything that comes in the first 62% I should give to him. I should party to the state of Madras.
ಪೋಸ್ಟ್ ಇಂಡಿಪೆಂಡೆನ್ಸ್ 1947 ನಂತರ ಭಾಷಾವಾರು ವಿಂಗಡಣೆ ಆದ ಬಳಿಕ ಈ ಎರಡು ಅಗ್ರಿಮೆಂಟ್ನ ಮುಂದುವರೆದ ಭಾಗವಾಗಿತ್ತ ಮೂರು ರಾಜ್ಯಗಳು ಒಂದು ಯೂನಿಯನ್ ಟೆರಿಟರಿ ಕೇರಳ ಮತ್ತು ಪುದುಚೇರಿ ಎರಡು ಆ್ಯಡ್ ಆದಾಗ ಈ ಅಗ್ರಿಮೆಂಟ್ನ ಮುಂದುವರೆದ ಭಾಗವಾಗಿ ನಾವು ಮುಂದಿನ ಇದನ್ನ ಅಗ್ರಿಮೆಂಟ್ನ ನೋಡ್ಬೋದಾ ಅಥವಾ ಅದು ಭಿನ್ನವಾಗಿದೆ ಅಂತ ಅನ್ಸುತ್ತೆ?
Well, there is a problem. In 1947, when British left India, they enacted the Indian Independence Act, under which the power over the British territory in India was transferred to the Constituent Assembly.
Okay.
With regard to the Maharajas, there are about 500 small princely states. The bigger was Hyderabad, and next was Mysore, Kashmir. They said that we will not transfer this power to the Constituent Assembly because we have no authority to transfer that power, whatever we had. We just withdraw ourselves, and we let these princes to decide themselves what they want. So they almost set them free to decide what they want. As we all know, Sardar Patel played an important role in persuading princes to join the dominion of India and be a part of India, to surrender their rulership. That is the process. But Section 77 nalli, Section 7 of the Indian Independence Act, not only abrogated the agreements with the Maharajas relating to the subsidiary alliance or whatever,
Okay.
they also abrogated all other agreements, including the agreements relating to the common concern, they called it, like irrigation, water, the electricity, port, all of them. But there is again a proviso that until a new agreement is worked out by the parties, the agreement will temporarily, for the time being, will continue. Right, there is a clause in Section 7.
Okay.
So under that, the 1924 and 1892 agreement continued.
Okay.
Then Dominion of India after British left further came out with a standstill agreement. That under the standstill agreement, the same what was there in the act, same was repeated, that all the agreements which are there so far will be continued temporarily until we negotiate and substitute them with a new agreement.
Okay.
Okay, but no new agreement came.
Okay. Till?
It never
Until?
came. Okay.
Okay.
Then in 1950, the old Mysore became a Part B state under the Union of India. They could have repudiated the agreement, whatever it is. They could have, they didn't do it. They could have denounced it. They didn't denounce it. Then in 1956, a larger Mysore was formed. That's present Karnataka, renamed in 1973 by adding territories of Bombay Presidency, Madras Presidency. Coorg came into the Mysore. Earlier, Coorg, where the Kaveri River takes birth, was a separate state by itself. It was called Chief Commissioner's Province of Coorg. So Mysore became bigger, and naturally Mysore started thinking in this bigger role and in this position under the Constitution, where all states are equal. That earlier thinking that we are the second-class citizens under the British Empire, where they are the superior ones, that doesn't exist. So Mysore started naturally asserting the right. Then initially they tried to work out within the agreement itself, 1924, thinking that this agreement has a life for 50 years. 1974 it goes, so why to create a problem? Within this agreement, whatever is there, let us take something. So they asserted the right to construct Himawati Reservoir and Kabini Reservoir, and that negotiation went on, but somehow it didn't work out. Finally, in 1968-69, around, Mysore got tired. So it got tired with these agreements and all. By that time, a lot of vices had started. In 1962 itself, Devegowda moved a resolution in the assembly,
Karnataka Assembly.
asking for cancellation of this agreement. Must terminate, who must withdraw from this agreement. So the pressure, political pressure had started. So finally, around 1969, Mysore said, we want to have a fresh negotiation. In any case, agreement is coming to end in 1974. We plan for a bigger Himawati. That's how Mysore said. We will not plan it under the agreement. but we'll plan it a bigger Hemavati, asserting our equitable share in the Kaveri. And 1972, an important meeting took place in Mysore under the chairmanship of the then Minister for Water Resources, Government of India, Irrigation, K.L. Rao. He was not only a politician but a great hydrologist by himself. And they arrived at some understanding that we'll have to appoint a committee to collect the facts, data, to take some good decisions.
Okay.
So that committee submitted a report collecting all the data. That was of great help in understanding what is what after a long time.
Okay.
So that committee report led to the draft agreement of 1974. And by the time the 50 years had also reached. So as soon as 50 years was over, Mysore said goodbye. We will not now release water as per the agreement. It will go as natural flow, whatever it is. And there's no obligation. That's how Mysore made it very clear. But Mysore was asked to sign the agreement of 1974 draft agreement. And but Tamil Nadu did not sign. Because in the meanwhile, President rule was imposed in Tamil Nadu in 1975 during emergency. So they didn't sign. And after emergency in 1978, some negotiations again started. Some Saldana committee was appointed. There were some concerns expressed by Tamil Nadu against the draft agreement of 1974. So that finally led to the, in 1981-83, farmers approaching the Supreme Court asking for a direction to the Government of India to constitute a tribe.
Okay.
Okay. So that writ petition was finally allowed in 1990, directing the Government of India to constitute a tribunal.
So it was farmers who
Yeah.
approached.
Yes, farmers approach.
Okay. So ಆ ಟ್ರೈಬ್ಯುನಲ್ಗೆ ಕರ್ನಾಟಕದ ಕಡೆಯಿಂದ ವಿರೋಧ ಇತ್ತು.
Well, our people, Karnataka opposed. I was not there at that time. And Karnataka very strongly opposed the constitution of a tribunal. The stand of Karnataka was now ಈ dispute-ನ ಮಾತುಕತೆ ಯಂತ್ರ ಬಗೆಹರಿಸಬೇಕು. Compulsory adjudication is not the way to resolve the interstate disputes. ಇಲ್ಲಿ ಯಾವುದೋ ಒಂದು interstate law ಅಂತಿಲ್ಲ. Nobody knows what are the rights of the parties. ಒಂದು legal rights ಬಗ್ಗೆ ಒಂದು ಲಾನೇ ಇಲ್ಲ ಅಂದ್ರೆ ವಾಟ್ ಇಸ್ ದ ಟ್ರೈಬ್ಯುನಲ್ ಇಸ್ ಗೋಯಿಂಗ್ ಟು ಅಡ್ಜುಡಿಕೇಟ್ ಅಂತ ಹೇಳಿ ಬಹಳ ವಿರೋಧ ಮಾಡಿದ್ರು. ಆದರೂ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಫ್ಟರ್ ವೇಟಿಂಗ್ ಫಾರ್ 7 years, after giving nearly about 15-20 opportunities to settle by negotiation, they said the time has come that we hold this dispute cannot be settled by negotiation. Therefore, under the section 4 of the Interstate Water Dispute Act, Government of India is under an obligation to constitute a tribunal.
Okay.
They issued a mandamus. That's how a tribunal was constituted on 2nd May 1990, pursuant to the direction. 2nd June 1990.
ಸೊ ಟ್ರೈಬ್ಯುನಲ್ನ ಕಾರ್ಯನಿರ್ವಹಣೆ ಹೇಗಾಗುತ್ತೆ ಸರ್? ಅಂದರೆ ಟೀಮ್ ಇರುತ್ತಾ? ಯಾರು ಟ್ರೈಬ್ಯುನಲ್ನಲ್ಲಿ ಇರ್ತಾರೆ? ಯಾವ ರೀತಿಯಾದಂಥ ಡಿರೆಕ್ಷನ್ಸ್ ಅವ್ರ ಕಡೆಯಿಂದ ಸಿಗುತ್ತೆ, ಅಥವಾ ಯಾವ ರೀತಿಯಾಗಿ ನ್ಯಾಯವನ್ನು ಎಕ್ಸ್ಪೆಕ್ಟ್ ಮಾಡ್ಬೋದು ಎರಡೂ ರಾಜ್ಯದ ಜನ ಟ್ರೈಬ್ಯುನಲ್ ಇಂದ?
Tribunal is a judicial body. It has to conduct the case. It has to adjudicate by following the procedure of due process. The Act says the tribunal can also investigate. So, to some extent, it is the investigative body also.
Okay.
So, the procedure of adversarial system, as you have in any other cases before the court, that means you make an allegation, other side admits or denies. If it denies, then it leads the evidence to prove its case. You lead the evidence to prove your case. Then the judge is like an umpire. He will decide. But tribunal ಸ್ವಲ್ಪ there is a creative role for a judge also.
Okay.
Okay, because it is not only an adversarial system which is followed. The provisions say that the tribunal has also got investigative powers. The party states may not take a proper stand for some reasons. That
ಫೇಲ್ ಆದರೆ
not fail because of various reasons. Nobody wants to reveal the cards. In interstate dispute, it happens that both the states think, why should I reveal my card? Why should I reveal do this? Anta ಹೊತ್ನಲ್ಲಿ the tribunal should independently think, investigate, and come to the conclusion what is right, what is wrong. and
ಆ
what
ಥರ
is-
ಆಗಿದೆಯಾ ಸರ್? ಟ್ರೈಬ್ಯುನಲ್ ಅದಾಗೆ
ಮಾಡ್ತಾರೆ.
ವಾಲಂಟರಿ ಆಗಿ ಇನ್ವೆಸ್ಟಿಗೇಟ್
ಮಾಡಿದ್ದಾರೆ.
ಈ ವಿಷಯದಲ್ಲಿ ಆಗಿದೆ,
ಇಲ್ಲಿ ಮಾಡಿ
ಕಾವೇರಿ
ಆಯ್ತು.
ವಿಷಯದಲ್ಲಿ. ಓಕೆ.
So every tribunal, first they give a full opportunity to the party states. And party states are also very conscious that if they do not reveal their cards, that tribunal will invoke its extraordinary powers. Okay, so they are also quite conscious. But despite that, sometimes tribunal also does it. So as a result of that, the adjudication does take time. Because each state has to lead its evidence of experts. So experts they're all very well-known experts of national, international reputation. They have to conduct a study. They can't just come and talk that comes to their mind. So every expert, before he files an affidavit, there will be years of hard study on that.
Research.
Research, collecting data, analysis, mathematical modeling, a lot of things take place. And there has to be agreement among the experts within the state itself, what to present, what not to present, how to present. So it takes time. Then after that, cross-examination starts. So if the expert has taken 2 years to prepare his study, naturally the cross-examination, which lawyers and engineers together prepare, it takes its own time. The questions are to be prepared. We have to sit with the lawyer, engineers. Engineers sit among as the first round among themselves. They come out with the draft questions.
Okay.
Then lawyers will sit, and there will be a lot of back forth understanding between lawyers and engineers. How to go about, what to frame. Then those questions are put to the witness in the court. Then that itself takes time again in the court. It's not 1 day affair or 2 day affair. Some witnesses are cross-examined for days. Some are cross-examined only for a few days. Today, in fact, I was recalling the cross-examination of Dr. Swaminathan,
Okay.
one of the great agricultural scientists in India. He was produced as a witness, star witness by the state of Tamil Nadu, to justify why 2 rice crop system, which Tamil Nadu farmers have been growing, is a justified system of cropping pattern. So that was the very important question on which Tamil Nadu was fighting, because Tamil Nadu asked for water to irrigate 5 lakh acres of Kurvai rice crop, followed by Thaladi rice crop. We said that, look here, this rice crop, Kurvai, Thaladi, double rice crop series, begins in June. Where do we have the rainfall in June? In Tamil Nadu, in Delta part. There is no rainfall because no southwest monsoon has any occurrence in Tamil Nadu in that part. ಸೊ ನಿಮಗೆ ರೇನ್ಫಾಲ್ ಬರ್ತಾ ಇಲ್ಲ ಅಂತಂದ್ರೆ ನೀವು ಯಾಕೆ ಅದನ್ನ ಗ್ರೋ ಮಾಡ್ತೀರಿ?
ನಾರ್ತ್ ಈಸ್ಟ್ ರೈನ್ಫಾಲ್
ಯಾವತ್ತೂ ಇರಿಗೇಷನ್ ಅನ್ನೋದೊಂದು ಏನಿದೆ, ಇದು ಸಪ್ಲಿಮೆಂಟರಿ. ದ ಕ್ರಾಪ್ ಕೆನ್ ನಾಟ್ ಬಿ ಸಸ್ಟೈನ್ ಓನ್ಲಿ ಆನ್ ಇರಿಗೇಷನ್. ಇಟ್ಸ್ ಅನ್ ಆರ್ಟಿಫಿಷಿಯಲ್ ವಾಟರ್, ರೈಟ್? ಡ್ಯಾಮ್ ನಲ್ಲಿ ನೀವು ಹೋಲ್ಡ್ ಮಾಡಿ ಬಿಡ್ತೇವ್ರಿ. ಅದನ್ನ should be used as a supplement, not as a complete as a main. Here 100% this crop is to sustain on the irrigation water. Therefore, it is not a justified crop. You should discontinue this crop. You can grow the second crop, Thaladi, or one long rice crop called Samba you can grow. That should be sufficient. To that extent, we recognize your right, prescriptive right, historical right, whatever is there, because existing economy has to be protected. We accept that. But you must change this. Then Swaminathan evidence was there. Fali Nariman, one of the great lawyer, cross-examined him for 2 days. It was a clash of giants in those days. Pack court hall, and both did exceedingly well in their own way. And finally,
if you can recall, sir, ಸ್ವಾಮಿನಾಥನ್ ಅವರು ಹೇಗೆ ಜಸ್ಟಿಫೈ ಮಾಡ್ಕೊಂಡ್ರು ಕ್ರಾಪ್ ಮೆಥಡ್?
ಸ್ವಾಮಿನಾಥನ್ ಅವರು ಹೇಳಿದ್ರು, if food self-reliance for the state is important, Tanjavur Delta has to grow rice, and it has to grow 2 rice. And this is a unique advantage the nation has got, agroclimatic features. We should not waste this. So that's how he put it. But we countered it by saying, look, there's nothing like a self-reliance of food in the country. Self-reliance of food is there for the nation, not for the states. Because there are no barriers between the 2 states with regard to the movement of rice and other thing. One can grow rice, one may not grow rice, one can export, send rice to other state. So there's nothing as such. Secondly, we said, you are saying unique agroclimatic features. But look at what is there in Karnataka. This is a drought area. People are not able to grow one ragi crop, right? The rainfall is hardly 550 to 600 millimeter. If you are not able to grow one ragi crop and living in a poverty, why should we give up our right to irrigate this land just to, as a support irrigation, as a dry irrigation it is called. We are not asking water for the rice, paddy. We are not asking for a second crop. Even first crop we are not asking. We are only asking water for growth of dry irrigation. That is whatever existing is there. ಅದಕ್ಕೊಂದು ನೀರು ಸಪ್ಲಿಮೆಂಟ್ ಕೊಡಲಿಕ್ಕೆ. ಸೊ ಇಂಥ ಹೊತ್ತಿನಲ್ಲಿ ನೀವು ಹೇಗೆ ಇದನ್ನು ಜಸ್ಟಿಫೈ ಮಾಡ್ತೀರಿ, ಇಟ್ ಈಸ್ ನಾಟ್ ಕರೆಕ್ಟ್ ಅಂತ ಹೇಳಿ ದಿಸ್ ಇಸ್ ವಾಟ್ ವಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ಡ್ ಇನ್. And it was a very extensive cross-examination for 2 days. And finally, happy that tribunal accepted our argument. They rejected Tamil Nadu's claim to 5.5 lakh acres of rice, that is Kurvai rice crop, double rice crop. They reduced it to 1,85,000.
Okay.
And for that requires 32 TMC of water. And that's how we succeeded in cutting down the requirement of Tamil Nadu.
ವೆನ್ ದ ಫೈನಲ್ ವರ್ಡಿಕ್ಟ್ ಕೇಮ್ ಸರ್, ಯಾವ ರೀತಿ ಈಗ ಇರುವಂಥ ನೀರನ್ನ ಹೇಗೆ ಹಂಚಿಕೆ ಆಗಬೇಕು ಅನ್ನೋ ಒಂದು ಫೈನಲ್ ವರ್ಡಿಕ್ಟ್ ಬಂತು. ಸೊ ಆ ಫೈನಲ್ ಅರೇಂಜ್ಮೆಂಟ್, ನೀರಿನ ಹಂಚಿಕೆ ಹೇಗಾಗಬೇಕು ಅನ್ನೋ ಕನ್ಕ್ಲೂಷನಿಗೆ ಬಂದಿದ್ದು ಹೇಗೆ, ಅದನ್ನು ಈಗ ರಾಜ್ಯಗಳು ಪಾಲಿಸೋಕ್ಕೆ ಆಗದೇ ಇರೋವಂಥದ್ದು ಒಂದು ಮಳೆ ನೀರಿನ ಅಭಾವದಿಂದ, ಕರ್ನಾಟಕದಲ್ಲಿ ಆಗುವಂಥ ಬರ ಸಮಸ್ಯೆಯಿಂದ. ಇಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಡಿಸ್ಟ್ರೆಸ್ ಫಾರ್ಮುಲಾ ಬೇಕಾಗತ್ತೆ. ಸೊ ಬಿಫೋರ್ ಗೋಯಿಂಗ್ ಇನ್ ಟು ದಟ್, ಈ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಬಗ್ಗೆ ಮಾತಾಡೋಣ ಸರ್, ಎಷ್ಟು ನೀರು ಹಂಚಿಕೆ ಆಗುತ್ತೆ ಅಂತ.
ಇಟ್ ವಾಸ್ ರಿಯಲಿ ಹರ್ಕ್ಯುಲೆಂಟ್ ಟಾಸ್ಕ್ ಫಾರ್ ದ ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ. ಬಹಳ ಕಷ್ಟ ಪರಿಸ್ಥಿತಿ ಟು ಆರ್ಗ್ಯೂ ಕೇಸ್ ಬಿಫೋರ್ ದಿ ಟ್ರೈಬ್ಯುನಲ್. ಯಾಕಂತ ಕೇಳ್ತೀವಿ, ಯಾಕಂತಂದ್ರೆ ಅಂಡರ್ 1924 agreement, we had given so much of water to the state of Tamil Nadu, Madras, which became Tamil Nadu. Over a period of 50 years, when that agreement operated, Tamil Nadu had received 380 TMC on an average at Mettur.
Okay.
Or about 260 TMC minimum flow it received.
Okay.
At the Mettur.
Okay.
Or about 245 at the border, you can say.
Okay. ಕಮ್ಮಿ ಅಂದ್ರು 240
at the border. At the Mettur, 260 minimum. Or on an average 320 to 380 it went. So much of water we had given under the agreement. And Tamil Nadu started claiming this is a historical right, this is my equitable share. I already developed an irrigation. I developed 28 lakh acres of irrigation. And therefore, I need this water. And there is a legal problem that law of water, even in the international law also, it always has a principle that first you must try to protect the existing irrigation. Okay. So, existing irrigation protection, adondu rule enittu, norm, international standard, that went to the help of Tamil Nadu.
Okay.
We try to argue that existing irrigation which Tamil Nadu has been claiming, 28 lakh acres, is an illegally developed irrigation. Actually, even 1924 agreement nago ishtu irlilla avrige. They have used the surplus water, which was supposed to be apportioned between the parties in 1974. They have unilaterally appropriated the surplus water and have expanded. Therefore, that should not be considered. This is not a legitimate existing irrigation, it's an illegitimate existing irrigation.
Okay.
So it was a tough time for us to argue.
Okay.
But finally, we succeeded to great extent. Today, if you look at under the 1924 agreement, we were giving minimum flow of 245 at the border, or altogether 320 at the border, or 380 at the Mettur. Today it is reduced to 174, and that too not minimum flow. It is on an average basis, or 50% dependability. In case of bad year, we have a distress formula. Okay, so it is really a big victory in that sense, compared to what we had given in the 1924 agreement. and what we got from the tribunal and finally from the Supreme Court.
ಬಟ್ ಆಗಿರುವಂಥ ಕ್ಲೈಮ್ಯಾಟಿಕ್ ಕಂಡೀಷನ್ಸ್ ಮತ್ತು ಈಗಿರುವಂಥ ಕ್ಲೈಮ್ಯಾಟಿಕ್ ಕಂಡೀಷನ್ಸ್ ಮಾನ್ಸೂನಿಗೆ ಬದಲಾಗಿದೆ ಅಲ್ಲ?
ಅಂಥದ್ದೇನು ಬದಲಾವ ಅನ್ನಿಸ್ಲಿಲ್ಲ. When you study the rainfall pattern, the average and all, there's not much of change.
Okay.
This has been extensively studied by the experts. The climatic change, whatever you call climate change, has really created some difficulties, like you get concentrated rainfall, you get cloud bursting, but rainfall is not that way reduced. But anyway, figures which are available in the government, which are maintained by the Indian Meteorological Organization, IMD, which are used for the purpose of estimation of the available water, that is based upon 1972 series. There's not much of change.
ಈಗಲೂ ತಮಿಳುನಾಡಿಗೆ ಕಾವೇರಿ ನೀರಿನ ಸಿಂಹಪಾಲು ಹೋಗುತ್ತೆ ವರ್ಡಿಕ್ಟ್ ಪ್ರಕಾರನೇ ನಾವು ನೋಡೋದಾದ್ರೆ.
Not. I don't agree. Not. It won't go. They have been cut short considerably, but still, well, I also feel another 20 teams should have been more reduced. Well, it should have been not 177, it should have been 150 or 140. Well, that is, but it's also true that we have gained considerably before the tribunal from what we were and what we are today. And also we have got the right over the surplus water, full right. Of course, there is a dispute on that. It has gone to the again Supreme Court to decide. But whatever it is, that is a still right we have got. And if we are able to construct this Mekeda 2, it also further helps in taking care of the distress here.
ಸೊ ಆ ಮೇಕೆದಾಟು ವಿಷಯಕ್ಕೆ ಬಂದಾಗ, ಮೇಕೆದಾಟು ರೆಸರ್ವಾಯರ್ನ ನಿರ್ಮಾಣದ ವಿಷಯಕ್ಕೆ ಬಂದಾಗ ತಮಿಳುನಾಡು ಮತ್ತೆ ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಿದೆ.
ಈ ಟ್ರೈಬ್ಯುನಲ್ ಏನಾಯ್ತಂದ್ರೆ, they apportioned the water at 50% dependability by taking 740 TMC as a distributable cake.
Okay.
So that is at 50% dependability. That means it may come in, out of 4 years, it will come in 2 years, it may not come. So what happens to those 2 years? The tribunal said in case of distress caused by less rainfall, you have to proportionately reduce your share. But this is a very vague term. Okay. How do you proportionally reduce? How do you assess?
How do you define it?
So all these problems came. And that's what we're witnessing these years. This problem arose in the implementation of the interim order in 95-96 when Devgowda was the chief minister. A committee was appointed to look into the needs of both the states and take a decision. Then it arose in 2002 and 3 when S.M. Krishna was the chief minister. 2012 and 13 and Shetter was the chief minister and Bommai was the irrigation minister. Then it arose in 2016 and 17. Siddhamaya was the chief minister and M.B. Patil was the minister for water resources. Now it has arisen this year. The only difference between this year and the previous years with regard to sharing of the distress is in the previous years when interim order was considered as the yardstick for sharing the distress based on same principle of pro rata or proportionate sharing, the load was high on Karnataka, right, 205. Secondly, the point of sharing was Mettur Reservoir. Mettur Reservoir has some problem with respect to the measurement of the water. It has an underestimation of 25 TMC to 30 TMC, which is consistently found to be underestimated. What you take at the Biligundu interstate border, water measured by the Central Water Commission, independent authority. At Mettur, it must increase because between Mettur and between the interstate border and Mettur, there is a land. Okay, that generates another 25 TMC.
Okay.
So if it is 200 at interstate border, it should become 225. But actually it becomes 175. This is a very serious matter. So the tribunal has resolved this, saying that Karnataka's obligation ends at the interstate border. So this 174 today, what I give is at the interstate border, right? And load reduced, point of measurement reduced. As a result, the problem which we had previous years, the 4 years I mentioned, where Krishna had to take Padayatra and all, it's not there this year. considerably less. That's why Supreme Court has not interfered or issued any direction, which is the most important thing that has happened this year.
Okay.
It has left it to the expert body
Okay.
to work out, and expert body has worked out. There are some grievances. It's not that we're happy. That we'll try to find out, but it's an expert body which has worked out.
Okay. So, and I'll come back to the Mekedatu Anekattu, sir.
Yeah. This Mekedatu question arises. As I said, the tribunal has distributed 740 TMC, a cake, at 50% dependability. That means every second year there is a surplus water. Okay. Every second year there can be a distress year and also a surplus year. So when a surplus year is there, what happens to the surplus water is the question. The Mysore, now Karnataka has asserted saying that my obligation is to give 177.25 TMC. Once I give that, whatever surplus is available in my territory is my water, right? That's how we asserted. And based upon that, and also fact that we have to give 177.25 TMC to Tamil Nadu at the border, why can't I generate electricity by making use of running water? So we have proposed a dam about 65 TMC storage. It has no direct irrigation from there. It cannot have. There's no place to irrigate there. It will only generate electricity from the water that has to be given to the state of Tamil Nadu, right? And it will also help the bondage to lift the water from the Bangalore water supply.
Drinking water.
Yeah, drinking water, because tribunal has given about 30 TMC to Bangalore itself. And that lifting is a problem presently. That it's not that we can't lift presently, we can lift from the river. But if you have a reservoir, the more stability will come. Right. Thirdly, we can store our surplus water of 13 TMC and use it in a bad year for Tamil Nadu. So Tamil Nadu also benefits to the extent of 13 TMC in a bad year.
But why is there still objections?
Well, Tamil Nadu shouldn't be objecting. Tamil Nadu should have agreed. But ಅವ್ರಿಗೊಂದು ಏನಿದೆ ತಲೆಯಲ್ಲಿ looks like, that's what they say. Once you construct a dam at the border, ನೀವು ಒಂದು ಡ್ಯಾಮ್ ಕಟ್ಬಿಟ್ರೆ ನೀವು ಒಂದು ರೀತಿ ಮೂಗು ಹಿಡ್ದಂಗೆ ಮಾಡ್ತೀರಿ. You will just hold us in such a way that you may give water, may not give water. Today, at least, water comes, according to Tamil Nadu, from the uncontrolled catchment, which is about 80 TMC. Okay. Actually, even that 80 TMC, which I get freely, when that gets stopped, then everything becomes at the mercy of Karnataka. Karnataka will have a tap at Mekedatu to give or not to give. That is their fear. It's not a proper fear. According to me, ತಪ್ಪಿದು ಹಂಗೇನು ಆಗಂಗಿಲ್ಲ. ನೀರು ಕೊಡ್ತೀವಿ, ಕೊಡಲೇಬೇಕು ವ್ಯವಸ್ಥೆಯಲ್ಲಿ, ಒಕ್ಕೂಟದಲ್ಲಿ, ಫೆಡರಲ್ ಸಿಸ್ಟಮ್ನಾಗೆ. ಬಟ್ ದಿಸ್ ಇಸ್ ದಿ ಫಿಯರ್ ದೇ ಹ್ಯಾವ್ ಜನರೇಟೆಡ್ among themselves, and on that basis they are opposing.
Okay. So ನೀವು ಕಾವೇರಿ ಲೀಗಲ್ ಟೀಮಿಗೆ 1991 ಅಲ್ಲಿ ಬಂದಿದ್ದು. 1990. ಸೊ ಇಷ್ಟು ವರ್ಷಗಳಲ್ಲಿ ಅನೇಕ ಮುಖ್ಯಮಂತ್ರಿಗಳು ಕರ್ನಾಟಕದ ಚುಕ್ಕಾಣಿ ಹಿಡಿದಿದ್ದಾರೆ, ಆಡಳಿತ ಚುಕ್ಕಾಣಿ ಹಿಡಿದಿದ್ದಾರೆ. ಒಬ್ಬೊಬ್ಬರ ಅಪ್ರೋಚ್ ಕಾವೇರಿ ಇಶ್ಯೂನಲ್ಲಿ ಬೇರೆ ಬೇರೆಯದ್ದಾಗಿದೆ, ಒಂದೊಂದು ಪಕ್ಷದ ಬೇರೆ ಬೇರೆಯದ್ದಾಗಿದೆ. ಇಫ್ ಯು ಕ್ಯಾನ್ ರೀಕಾಲ್, ಯಾವ ಚೀಫ್ ಮಿನಿಸ್ಟರ್ ಏನ್ ಮಾಡಿದ್ರು, ಅಂಡ್ ಇಫ್ ಯು ಕ್ಯಾನ್ ರೀಕಾಲ್ ಯಾರ್ದು ಔಟ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಅಂತ ಅನ್ಸುತ್ತೆ ಅಂತ?
Well, it's very difficult to say. I was appointed in 1990. The first chief minister at that time was Virendra Patil. I didn't have an opportunity to interact with him, but he was a very good administrator. What I learned from my senior colleagues. Then came the chief minister Bangarappa in 1992. I knew him also otherwise, and at that time issued the ordinance. And I was very closely involved in the drafting of the ordinance and the implementation and the litigation at that time, and the subsequent year what happened after the failure of the ordinance.
ಸುಗ್ರೀವಾಜ್ಞೆ ಡ್ರಾಫ್ಟ್ ತಯಾರು ಮಾಡುವಾಗ ಅದರ ವಿರುದ್ಧವಾಗಿ ನೀವು ನಿಮ್ಮ ಇದನ್ನು ಕೊಟ್ಟಿದ್ರ ಸರ್?
No, that draft was prepared by the legal team, to be fair. It was an understanding that state has a right to use water unless there is a final award issued by the tribunal. So in turn, we questioned the order of the tribunal, the powers of the tribunal to pass interim order. Either you have the power, if you don't have the power, I have the power to issue ordinance. That's how the question was tried to be raised there. Right? We failed in that. It's okay. That was the constitutional assertion of right we had, saying that tribunal doesn't have power to issue interim order. Therefore, my ordinance to use water until the tribunal gives a final order is not wrong. Whose court didn't agree. We failed. But that was the time lot of tension was in Karnataka. Bangarappa was chief minister. He was a flamboyant chief minister. And it was something good experience to work with Bangarappa. I was a very junior counsel, but I had a very we had a good experience of learning from his discussion, interaction. He used to take a lot of interest. It was very
And that was also a challenging phase.
challenging phase. He was ably assisted at that time by Virappa Moily. He was the Minister for Law, very ably assisted. And Bangarappa, whatever their political problems, he relied upon Moily fully. There was also one fine irrigation minister, Mallari Gowda Patil from Belgaum. It was a good team at that time to begin with. Then after Bangarappa, Moily became a chief minister. Since Moily was fully involved in the organization of the legal team, the Kaveri cell in Delhi, so the chief minister naturally he took interest in conducting the case much more in a professional way. Then Mr. H.D. Devegowda, the chief minister, man from
Kaveri belt.
Kaveri art, and I already known him very closely as an opposition leader. So as soon as he became a chief minister, and Devegowda's style of functioning is different. Every second day he would telephone. Every second day there used to be discussion how to go what to do. He was a man of real passion for Kaveri. Well, and it also happened that during his time it was a bad year. And it so happened in December 1995, we had to face the order of the Supreme Court and tribunal for release of 12 TMC or something. And here the opposition was not willing to cooperate. And including the central ministers from the Congress party were opposing. So question arose how to release. Then matter came up in the Supreme Court on 28th of December. It was a very bad cold. The court found that, it's a very difficult question. So why don't you ask the Prime Minister to resolve this tangle? So they directed in most unprecedented order, directed the Prime Minister to convene the meeting of both the chief ministers and the floor leaders of both the states and resolve the issue with regard to the release of 11 TMC of water. It's not 12, 11. Then Prime Minister called the meeting, 6th January immediately. Then we all know that he said, you first release 6 TMC, and they would have obeyed the direction of Prime Minister and release 6 TMC.
P.V. Narasimha Rao.
Yeah. Then for remaining 5 TMC, they appointed a committee of alleged professor to investigate and guide the government how to go about it. But by the time report came, the water also went on its own natural flow. So problem got solved. But this is a time when Devegowda became very close to the Mr. Narasimha Rao and gained confidence of him for keeping the word also. Well, according to me, that helped him in becoming the Prime Minister. That's
You call him a master litigator. ನಾನು ಅವರ ಪ್ರೈಮ್ ಮಿನಿಸ್ಟರ್ ಬಯೋಗ್ರಫಿ ಫರೋಜನ ಫೀಲ್ಡಲ್ಲಿ ನಿಮ್ಮ ಕೋಟ್ ಓದಿದ್ದೀನಿ. That you say you call him a master litigator, and you say he believes in the politics of litigation, while many of the politicians believe in power of agitation, politics of agitation ಅಂತ. ಸೊ ಪವರ್ ಆಫ್ ಲಿಟಿಗೇಷನ್ ಅಷ್ಟು ಇನ್ವಾಲ್ವ್ ಆಗಿದೆ ಅಂದರೆ ಪ್ರತಿದಿನ 2 ದಿನಕ್ಕೊಮ್ಮೆ ಲೀಗಲ್ ಟೀಮ್ ಜೊತೆ ಫೋನಲ್ಲಿದ್ರು ಕಾವೇರಿ ಇಶ್ಯೂನ ತುಂಬ ಪ್ಯಾಷನೇಟ್ ಆಗಿ ಅವ್ರ ಮನಸ್ಸಿಗೆ ಹಚ್ಕೊಂಡು ತಗೊಂಡಿದ್ರು ಅಂತ. ಪ್ರೈಮ್ ಮಿನಿಸ್ಟರ್ ಆಗಿರುವಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಕಾವೇರಿ ಇಶ್ಯೂ ಕುರಿತಾಗಿ ಎನಿ ಆಫ್ ದ ಮೂವ್ಸ್ ದಟ್ ಯು ಕ್ಯಾನ್ ರೀಕಾಲ್?
Yeah, as a prime minister, it so happened as soon as he became prime minister, the Almaty issue started. The Andhra Pradesh High Court at Hyderabad passed an order directing the cabinet secretary to issue instruction to Karnataka to stop the construction of Almaty Dam. So that was a very devastating direction. And suddenly there was hell in the Karnataka Assembly. And the UDF government, United Democratic Front, which Chandrababu Naidu was the main partner, he made a big issue. The court direction is there. Now you must issue a direction to the Karnataka. The cabinet secretary should issue. That means central government must issue a direction to Karnataka. Central government was headed by Mr. Devegowda. So it was a very difficult one. And Devegowda was very much concerned because he was not a chief minister, he was the prime minister. He has to be a neutral person. And he used to have a lot of discussions with us. He used to have discussions with Tamil Nadu also, and Andhra Pradesh also. He was quite even-handed, no doubt. And finally, the committee was appointed, UDF committee, headed by Ghoshal, the chief engineer of the West Bengal. And we all visited the basin area. At that time, Andhra Pradesh was represented by N.V. Ramana, advocate, who became the Chief Justice of India later. And this side I was there in the tour and all. And well, that brought about some solution at that time. The committee recommended that Karnataka can construct in the first stage up to 519. And for the remaining 524, it has to go to the tribunal when it gets allocation of surplus water, the scheme B. So that's how the litigation got sidetracked then in those days. But again, we had to file a complaint and have the second tribunal constituted a separate thing. So that was the contribution of Devegowda as the chief minister, as a prime minister, and he was really a real master. And he was of great help in devising the distress formula. Because till he became a chief minister, we all thought that sharing of a distress means go by the whatever is available in the reservoir or the Karnataka state border, then share it in a proportionate manner. If there is 50% distress or 60%, whatever, 45%, give that much less.
Mathematically,
that's how. But one day he called me and he used to always say, Guru, then took a pen, he started explaining to me. See, look here, I give my water and he gets quota in my water. And northeast rainfall, which starts in October, turns out to be normal. He's normal. Then only I lose my water. This is not fair. So then myself, he and one former minister, Poddar, was there. We all went to Nariman. And Nariman heard it and he was also convinced there is a point. So Karnataka started changing its stand immediately. Then what we had already taken a stand that the distress at the border will be shared in a mathematical manner. So that was a significant thing we did. And since then, we are looking at a formula how to share this at the border by taking into consideration the ground realities or the happenings in Tamil Nadu, all these things.
Of that year?
Yeah. Every year, whenever the distress occurs. After Devegowda, the chief minister was J.H. Patel. J.H. Patel was a very witty person. Okay, everything. He knew a lot of things. He didn't take a direct interest. He left it to the then irrigation minister, Mr. Nagegowda. He was also very enthusiastic minister. But Patel had a sense of humor, always used to cut jokes and lighten the mood in the meetings. He had his own way of dealing. And after Patel came Mr. S.M. Krishna. S.M. Krishna had his own way of dealing with things. He was again assisted by very able irrigation minister H.K. Patil. And that's how it went about. With Patel, I must tell you, one person who really also helped him was Mr. Nanaya, Minister for Law. He was really a brain for him, for all purpose. So Nagegowda and Nanaya made a good team to handle the crisis. Then S.M. Krishna, it was all handled by H.K. Patil. But S.M. Krishna also used to take his own interest. In fact, he went on Padayatra during the crisis in 2002 and 3. Then after that, S.M. Krishna came Dharam Singh. Dharam Singh was a short period. Then thereafter, Kumaraswamy came, a short period. Then came Yediyurappa. During Yediyurappa time, it was actually the man in command was Bommai, who effectively took control of the situation, and he was completely commander in chief as far as the water is concerned. Then after Bombay, during Bombay time, Mr. Shettar became a chief minister during 2012 and 13 crisis. I must say, despite their political differences, Shettar and Bombay, in handling of the 2012 and 13 crisis, they were one, and understanding between them was very good.
Okay.
There was no at all misunderstanding. Whatever there may be Hubli Dharwad politics, but both of them handled it very well. Both of them from non-Kaveri area. It was not easy to handle a Kaveri dispute for politicians who are from non-Kaveri area.
ಆರ್ ಸರ್, ಇಮೋಷ್ನಲಿ ನೋಡದೆ ಇದನ್ನ ರೀಸನ್ ಲಾಜಿಕಲಿ ನೋಡೋದು, ಕ್ಯಾನ್ ದಟ್ ಬೆನಿಫಿಟ್ ಅ ಚೀಫ್ ಮಿನಿಸ್ಟರ್?
Well, it depends upon how it helps. Every chief minister is emotionally involved. Then we have the next chief minister, Siddaramaiah. Siddaramaiah was really good in 2013 to 2018, that period. See, Siddaramaiah had his own way of doing. Thrice he invited me to the cabinet meeting, and he, being a lawyer, strictly goes by the legal advice. One thing about Siddaramaiah, very strictly goes by the legal advice. There's no doubt about it. But overall, the command used to be in the hands of Nariman those days. Because Nariman was treated like a god by everyone. So after that, we had in between for a small time, Sadananda got our chief minister. Then after Siddaramaiah, the again chief minister, Mr. Yediyurappa came. Then Bommai came. Now again Siddaramaiah back. So I had the privilege of seeing so many chief ministers. Not only as chief ministers as an opposition leader, then back as chief minister, then back as opposition leader. So I have seen all these eminent politicians of Karnataka.
ಸೊ ಅವ್ರ ಒಪಿನಿಯನ್ ಅವರು ಆಪೋಸಿಷನ್ ಅಲ್ಲಿ ಇದ್ದಾರಾ ಅಥವಾ ಪವರ್ ಅಲ್ಲಿ ಇದ್ದಾರಾ ಅನ್ನೋದ್ರ ಮೇಲೆ ವೇರಿ ಆಗುತ್ತೆ ಈ ಇಶ್ಯೂ ಬಗ್ಗೆ?
ಹಂಗೇನಿಲ್ಲ. One good thing about Karnataka is that decisions are always taken by the all party meeting. ಆಲ್ ಪಾರ್ಟಿಯಲ್ಲಿ ಎಲ್ಲರೂ ಬರ್ತಾರ, ಎಲ್ಲರೂ ಕುಂಡಿರ್ತಾರ. ಆಲ್ ಆಫ್ ದೆಮ್ ಟಾಕ್ ನೈಸ್ ಥಿಂಗ್ಸ್ ಅಂಡ್ ಸೆನ್ಸಿಬಲ್ ಥಿಂಗ್ಸ್, ಅಂಡ್ ದೇ ಕಮ್ ಟು ಅನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್. ಔಟ್ಸೈಡ್ ದಿ ಆಲ್ ಪಾರ್ಟಿ, ವೆನ್ ಯು ಗೋ ಬ್ಯಾಕ್, state level politics, taluka level politics, district level politics differs. Local people have their own anguish, have their own grievances, their own things. You can't suppress them. You should allow it to play. So they have some agitation, some kind of things happen that can't be stopped. But largely, all decisions are finally taken by the all party meeting, and that is the strength of Karnataka in conducting the water disputes.
Okay. ಸೊ ಈಗ 161 ತಾಲೂಕುಗಳಲ್ಲಿ ತೀವ್ರ ಬರ ಅಂತ ಘೋಷಣೆ ಆಗಿದೆ ಸರ್ ಈ ವರ್ಷ. ಸೊ ಸಂಕಷ್ಟ ಸೂತ್ರ ಬೇಕೇ ಬೇಕು. ಈ ವರ್ಷದ ಸಂಕಷ್ಟ ಸೂತ್ರ ಕರ್ನಾಟಕದ ರೈತರ ಪರವಾಗಿ ಇರಬೇಕು ಅನ್ನುವಂಥ ಕೂಗು ಕೇಳ್ತಾ ಇದೆ. ಸೊ ದಟ್ ಇಸ್ ವೈ ವಿ ಆರ್ ವಿಟ್ನೆಸಿಂಗ್ 2 months in a week's time. ಈ ಫಾರ್ಮುಲಾ, ಡಿಸ್ಟ್ರೆಸ್ ಫಾರ್ಮುಲಾ ಈ ವರ್ಷಕ್ಕೆ ಹೇಗೆ ಬರೋಕ್ ಸಾಧ್ಯ? ವಿಲ್ ಇಟ್ ಹೆಲ್ಪ್ ಪೀಪಲ್ ಆಫ್ ಕರ್ನಾಟಕ? What can we hope?
Yeah, if I have to talk independently about the distress formula, as I told you, the tribunal has distributed the water at 50% dependability, 740, right? Interim order also based upon average. So what happens when the water is not available to the extent they assumed? Okay. So if it is less than 740 teams in the basin or 483 at the interstate border, it is considered to be distress year. Then how do you share? The tribunal has said you share it in a proportionate manner. The expression which they had used in the interim order was pro rata. Both are same, right? But there is a very important judgment of US Supreme Court with regard to the Rio Grant, that distress formula of pro rata sharing, though it appears equitable on the face of it,
Okay.
it may not be true. because during the years of distress, the priorities of users change. So mathematical reduction of water does not work equitably. First, you have to give importance to the drinking water. So you have to next you have to give importance to the life-saving irrigation. So like that it goes. It can't be just a mathematical deduction. So that's how the US Supreme Court said it. Now the question is, how do you assess the distress share of a state? Tamil Nadu says, look here, if there is a shortfall of water that in a normal year in Karnataka catchment 483 comes
Okay.
out of 743. If in the 483 there is a shortfall of 20%, 30%, you give me 30% or whatever less. So that's how mathematically Tamil Nadu argues. That's a simple formula. We say this formula is a reductionist formula, simple mathematics. It doesn't work like that. This will cause a great injustice to Karnataka because in a distress year, my problems are different. And secondly, based upon this mathematical formula, I give you your share of water.
Okay.
Okay, the northeast rainfall, which occurs after October, turns out to be normal, and normally northeast and southeast don't go together. The rate of failure of northeast is less, and you get that normal water, and I suffer here, and in my suffering also you take a share, and you have a full northeast rainfall. Apart from that, you have got a groundwater in the delta, abundant groundwater. So you live a normal life. First of all, you have got a large irrigation, disproportionate to equitable share. In the name of historical irrigation, existing irrigation, you have been able to get that. Right. Secondly, in a distress year also, you get a line share. So this is unjust. This is how we argue. According to us, you will have to take into account the northeast rainfall, which is likely to start in the month of October. Take into account the groundwater which is available properly, and take into account the distress in the intermediate catchment in Karnataka properly, and come to some kind of an understanding based on ground realities. And this is what the CWMA, that is Kaveri Water Management Authority, last time did in the month of September. They said that at the reservoir there is a distress of 53%. So what works out is 6,400 cusecs to be really ensured at the border on this basis. But we apply further correction based on other factors and reduce it to 5,000. This is upheld by the Supreme Court. So whatever the mathematical reduction take place, over that there has to be a correction factor to accommodate the ground realities. And that's what emerges from the order of the CWMA, which Supreme Court fortunately upheld in its last hearing.
Okay.
So this you can call a sort of an ad hoc formula, but it's a very good development. It has partly solved, if not fully, the problem of sharing water in a distress situation.
ಈಗ ಸಮಸ್ಯೆ ಆಗಿರೋದು ನಮಗೆ ಕುಡಿಯೋಕೆ ನೀರಿಲ್ಲ, ನಿಮಗೆ ಇರಿಗೇಷನ್ಗೆ ಕೊಡ್ಬೇಕಾ, ನಾವು ನಿಮಗೆ ವ್ಯವಸಾಯ ಕೊಡ್ಬೇಕಾ ಅಂತ.
Correct. See, today, if you ask me, situation in this year, my dam has about 48 or 49 TMC as on today, live storage, all four reservoirs added together. I may get another 10, 15 TMC. Okay. If I get more, it is fine. But I don't think we get more than that. So I will have about 65 TMC roughly. Now, what are my needs? Number need drinking water for Bangalore. It has to be given. You can't reduce it. You can't ask people to drink half a glass in the bad year. So we have to give 33 TMC, whatever we calculated, Bangalore and other cities. So for irrigation, about 35 TMC. Whereas our irrigation requirement and drinking water together is 106. That means for irrigation, about 70 TMC we need. So we have only 35 as it is. So our farmers will have to tighten the belt. It is very painful for them. So, but this is a distress here.
ಒಂದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ಒಂದು ಅನ್ಯೂಶುವಲ್ ಡೈರೆಕ್ಷನ್ ಬಂತು, ಲೆಟ್ ದ ಪ್ರೈಮ್ ಮಿನಿಸ್ಟರ್ ಗಿವ್ ಸಮ್ ಡೈರೆಕ್ಷನ್ ಅಥವಾ ಗೆಟ್ ದ ಪಾರ್ಟೀಸ್ ಟುಗೆದರ್ ಅಂತ PV ನರಸಿಂಹರಾವ್ ಅವರಿರುವಂಥ ಸಂದರ್ಭದಲ್ಲಿ, ಪ್ರೈಮ್ ಮಿನಿಸ್ಟರ್ ಆಗಿರುವಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಆ ಅನ್ಯೂಶುವಲ್ ಡೈರೆಕ್ಷನ್ ಯಾಕೆ ಸುಪ್ರೀಂ ಕೋರ್ಟಿಂದ ಬಂತು? ಅಂಥ ಡೈರೆಕ್ಷನ್ ಇವಾಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋಗುವಂಥ ಸಾಧ್ಯತೆ ನಮಗೆ ಕಮ್ಮಿ ಇರೋದ್ರಿಂದ, ಯಾಕಂದರೆ ಇಟ್ ಬಿಲೀವ್ಸ್ ಇನ್ ದ ಟ್ರೈಬ್ಯುನಲ್ ಆ್ಯಂಡ್ ದ ಅಟಾನಮಸ್ ಪಾರ್ಟೀಸ್, ಕಮಿಷನ್ ಆ್ಯಂಡ್ ದ ಟ್ರೈಬ್ಯುನಲ್. ಸೊ ಈಗ ಆ ರೀತಿಯಾದಂಥ ಒಂದು ಡೈರೆಕ್ಷನ್ ಪ್ರೈಮ್ ಮಿನಿಸ್ಟರಿಗೆ ಬರುವಂಥ ಸಾಧ್ಯತೆ ಇದೆಯಾ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನಿಂದ?
See, 1995, it was a situation developed into a crisis. The tribunal directed Karnataka on 19th of December to release, to ensure 11 TMC of water to Tamil Nadu. We are not able to really do that. Not that we are not willing to do, but we said it takes time to take people into confidence. People are completely mad at it. They're all ellaru agitation ittu joragi. So then we delayed. In the meanwhile, Tamil Nadu went to the Supreme Court. Supreme Court 28th of December, in the vacation, they had a special sitting. So K. Ramaswamy and Justice Agarwal, they sat and they understood our problem. We showed them all the records. It's not that we don't want to release, but look here, the difficulty is this. Forthwith release andre happenilla. It takes time. And we have to generate a cooperation of opposition and make people understand the legal implication and do it. So then they understood the genuineness of the plea of Karnataka and the difficulties. Then they directed, let the Prime Minister convene the meeting of the chief ministers of both the states and the leaders of opposition. He said so because we pointed out to the court in the affidavit of the Home Secretary that even the union minister belonging to the opposition party had participated in a meeting asking us not to release water. If the union minister comes and says don't release water, how do you release water? So that's how we argued. Then judges said, okay, we understand the difficulties of both the states, your politician, their politician. Therefore, we direct Prime Minister to call the meeting of chief ministers, leaders of opposition of both the states, and work out a solution amicably with regard to the implementation, not to change the order. Order cannot be changed by the Prime Minister. It is only how to implement it. So Prime Minister implemented it by first directing Karnataka to release immediately 6, which they were honored. Another 6 TMC, the Prime Minister said, I will appoint a committee, it will decide how to release. So they came and gave a recommendation. By the time water went down. So the basic argument which Karnataka was making, that forthwith release is not possible, but really water will go in course of time, in a period of 15 days or a month, that proved to be correct.
Now that Congress government here, Karnatakadalli, is asking Prime Minister's intervention. Adre ivaga the challenge here is both the governments here in Karnataka and in Tamil Nadu are part of India Alliance. So BJP here in Karnataka is asking, ನೀವು ಯಾಕೆ ನಿಮ್ಮದೇ ಒಕ್ಕೂಟದಲ್ಲಿ ನೀವೊಂದು ತೀರ್ಮಾನಕ್ಕೆ ಬರಬಾರ್ದು, ನೀವೊಂದು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗಿಗೆ ಬರಬಾರ್ದು ಅಂತ. So it becomes a checkmate kind of a situation for both the parties.
Yeah, politically things are different. Yeah. But if you ask me on the point of constitution,
from legal point,
there was a discussion in the government that we should appeal to the Prime Minister to review the order of the CWMA directing Karnataka to release 5,000. Then I gave a written opinion that you can't ask for a review because no such powers are there for the Prime Minister to correct the order. All that you can request to the Prime Minister is to, as the head of the family or to the central government, to convene the meeting of the chief ministers or the chief secretaries or whatever, and if possible, mediate to arrive at an amicable solution. But the precondition is that both the states must agree. Okay. So this is something, a attempt to solve the problem outside the court. Okay. If two parties agree in any civil matter to solve it amicably, naturally the agreement or a compromise, or we call it in Kannada upsadante now, it will be filed before the court. Court can always substitute the decree by the compromise. So in that sense.
ಈಗ ದೇವೇಗೌಡರ ರೀಸೆಂಟ್ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ನಾನು ಕೇಳಿಸ್ಕೊಳ್ತಾ ಇದ್ದೆ, ವೇರ್ ಹಿ ಸೇಸ್ ಕಾನೂನಿನ ಆಚೆಗೆ ಕಾನೂನಿನ ಹೋರಾಟ ಅಲ್ಲದೆ ಅಮಿಕಬ್ಲಿ ನಾವು ಹೇಗೆ ಸೆಟಲ್ ಮಾಡ್ಕೋಬಹುದು ಕೋರ್ಟ್ನ ಹೊರಗಡೆ ಅನ್ನೋದು ಕಾವೇರಿ ಇಶ್ಯೂನಲ್ಲಿ ತುಂಬಾ ಪ್ರಮುಖವಾದ ವಿಷಯ ಅಂತ. ಈಗ 15-20 ಆ ರೀತಿಯಾದಂತಹ ಚಾನ್ಸಸ್ನ ಕೊಟ್ಟ ಆದ್ಮೇಲೆ ಕೋರ್ಟ್ ಇಂಟರ್ವೀನ್ ಆಯ್ತು ಪೋಸ್ಟ್ ಇಂಡಿಪೆಂಡೆನ್ಸ್ ಅಂತ ನೀವು ಹೇಳಿದ್ರಿ. ಈಗ ಆ ತರದ ಒಂದು ಸೆಟಲ್ಮೆಂಟ್ ಆಗುವಂತಹ ಸಾಧ್ಯತೆಗಳು ಇರುತ್ತಾ ಬಿಯಾಂಡ್
Well,
ಲೀಗಲ್ ಸಿಸ್ಟಮ್?
nobody can rule out the settlement if two states agree.
Yeah.
Suppose there is a better understanding, new facts come, they can always negotiate at the farmers level, then at the civil society level, then develop into a sort of a larger understanding at the government level. Can do that, but not that easy. Particularly once a judgment has come through a long litigation, to replace it with a negotiated settlement is not easy, but nothing wrong in trying. It's always helpful to have a negotiated settlement of any dispute. It is easier to implement for the parties because the judgment means it is an imposition. The agreement means you are voluntarily
It's an
agreed.
understanding.
So voluntariness always helps.
ಕಾನೂನಾತ್ಮಕ ಹೋರಾಟದಲ್ಲಿ ಕರ್ನಾಟಕದಿಂದ ಮುಂದಿನ ನಡೆ ಏನು ಸರ್ ಕಾವೇರಿ ವಿವಾದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಹಾಗೆ?
The Kaveri has been partly depoliticized and has also been de-judicialized because the Supreme Court directed for the constitution of CWMA, Kaveri Management Authority, and Kaveri Water Regulation Committee. This two-tier process is there. These are the expert bodies. Once the matter is before the expert body and they decide, the courts are reluctant to interfere.
Okay.
And that's what is happening. To that extent, the dispute has gone out of the court. But it's not that completely it has gone out. Court can always exercise the jurisdiction. Even now they say that if we find something is arbitrary or they acted upon some irrelevant consideration, we interfere. Okay, but still largely being an expert body, there'll be a lot of deference, respect for the CWMA. So whatever our grievances are there now, with regard to the sharing of justice, we'll have to get it resolved through the CWMA.
ಸೊ CWMA ಆಗಿರ್ಬೋದು, CWRC ಆಗಿರ್ಬೋದು, ಇಲ್ಲಿ ಫೇರ್ ಮಾನಿಟರಿಂಗ್ ಆಗತ್ತೆ ಅಂತ ಸಾಮಾನ್ಯ ಕನ್ನಡಿಗ ಒಬ್ಬ ಹೇಗೆ ನಂಬೋದು ಸರ್?
ಸಾಮಾನ್ಯ ಕನ್ನಡಿಗರಿಗೆ ಹೀಗಿದೆ, it is a long process. We have to educate our people also in Karnataka, so as Tamil Nadu in their state. What is this interstate water dispute? If every child is taught the principle that water of an interstate river has to be shared, it helps a lot. Today, people in Karnataka, common man thinks, ನಮ್ಮ ವಾಟರ್ ನಾವೇ ಕೊಡ್ಬೇಕ್ರಿ, ನಮಗೆ ಇಲ್ಲ ಅವ್ರಿಗೆ ಅದು ಕೊಡ್ಬೇಕು ನಾವು. It's a very powerful argument. Okay, so but we'll have to really convince that international, national, everywhere, the tested and tried principle is sharing water. It is the heritage of mankind. It's not that it is produced in Karnataka in that sense or in Maharashtra. ಯಾಕಂದರೆ ನಾಳೆ ಮಹಾರಾಷ್ಟ್ರ ಹೇಳ್ಬೋದು ಕೃಷ್ಣ ವಾಟರ್ ಎಲ್ಲ ನಂದು, ನಾನು ಕರ್ನಾಟಕಕ್ಕೆ ಕೊಡೋಂಗಿಲ್ಲ. ಅವ್ರು ಚೈನಾ ಹೇಳ್ಬೋದು ಬ್ರಹ್ಮಪುತ್ರ ವಾಟರ್ ಎಲ್ಲ ನಂದು, ನಾನು ಇಂಡಿಯಾಕ್ಕೆ ಕೊಡೋಂಗಿಲ್ಲ. ಸೊ ಇವೆಲ್ಲ these things have to be told to the people. Tamil Nadu also must educate its people in the name of historic irrigation and all, and what we have illegally developed. You can't ask for a protection of all that. Karnataka also has to live. It is a drought area. People are crying for one simple dry irrigation, and you people are having 2 rice crop. Even one rice crop, long rice crop, yields income which is almost 80 to 90,000 rupees per year, 1 acre. Whereas 1 acre of ragi land, even after irrigation, will not give more than 15-20,000. Without irrigation, it won't give on 5,000. With irrigation also, it won't give more than 15-20,000. When that is the situation, people of Tamil Nadu must also be educated the situation here. Otherwise, I talked to a lot of people in Tamil Nadu when I had gone there. They all think that Karnataka has so many dams. 1,000 TMC ಹಿಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರು ಸಮುದ್ರಕ್ಕೆ ಡೈವರ್ಟ್ ಮಾಡ್ತಾರೆ. ಆಲ್ ಕೈಂಡ್ ಆಫ್ ದಿಸ್ ಕೈಂಡ್ ಆಫ್ illiterate thinking is there. Okay, sort of a narrative is built in both the states. Okay, that has to be changed. It has to first change in Tamil Nadu. It should change in our state also, that we have to share water. So we can't just say, I'll not give anything. Okay. And what is to be given, finally, the expert body will decide. If there are any problems, then the court is there, the highest court of the land. Supreme Court will decide. And we should obey that. We can't have a process much fairer than this.
My last two concluding
Sure, sure.
questions, sir. CWMA ನಲ್ಲಿ ಯಾವ ಎಕ್ಸ್ಪೆಕ್ಟೇಷನ್ಸ್ ಇದೆ, ಏನು ನಮ್ಮ ಪರವಾಗಿ ಬರಬಹುದು ಅಂತ ಎಕ್ಸ್ಪೆಕ್ಟೇಷನ್ಸ್ ಇದೆ?
We do guide the government how to present their arguments and prepare their submissions and all. Right. The expectation is, so far, it is not bad, but it is not completely good. Okay. So we all feel I should have been less burdened. ಲಾಸ್ಟ್ ಟೈಮ್ 5,000 ಕೊಟ್ಟರು, 5 ಕೊಡಬಾರ್ದಾಗಿತ್ತು, 3. ಈ ಸಲ 3 ಕೊಟ್ಟರು. ವಿ ಫೀಲ್ ಇಟ್ ಶುಡ್ ಹ್ಯಾವ್ ಬಿನ್ ಲೆಸ್, 2.5. So that kind of grievance is always there. Hope that as the technology improves, the data improves, we will be able to convince them better in taking a more rational decision. See, one of the important thing about water dispute is the good science, good technology, good data. If you have the good data, good science, you are able to win a case, not otherwise. Okay, so those things have to be collected. We can just also throw the data at the CWMA. We have to logically arrange it. We must put in a legal sequence, in a legal logic, what is relevant, irrelevant, present it properly, and as the time goes, we should be able to do it better. But at the moment, this is a situation. We are not fully dissatisfied, but not fully happy.
ಮೇಕೆದಾಟು ಅಣೆಕಟ್ಟು ಕಾವೇರಿ ಸಮಸ್ಯೆ, ಕಾವೇರಿ ವಿವಾದಕ್ಕೆ ಒಂದು ಶಾಶ್ವತ ಪರಿಹಾರ ಕೊಡೋ ನಿಟ್ಟಿನಲ್ಲಿ ಅನುವು ಮಾಡಿಕೊಡುತ್ತಾ? ಆ ನಿಟ್ಟಿನಲ್ಲಿ ನಮ್ಮ ಲೀಗಲಿ ನಾವು ಯಾವ ಸ್ಟ್ಯಾಂಡ್ ಪಾಯಿಂಟ್ ಎಲ್ಲಿದ್ದೀವಿ ಈ ಹಂತದಲ್ಲಿ?
Say, we proposed Mekedatu project, and we have prepared the project report also. Tamil Nadu challenged it and has gone to the Supreme Court. Allondu miscellaneous petition ಹಾಕ್ಯಾರ. The 2018 judgment ಆಯ್ತು, ಸಿವಿಲ್ ಅಪೀಲ್ನಲ್ಲಿ ಒಂದು ಅದರಲ್ಲಿ ಹಾಕ್ಯಾರ, ದಟ್ ಸೇಯಿಂಗ್ ದಟ್ ಕರ್ನಾಟಕ ಹ್ಯಾಸ್ ಬಿನ್ ಕನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಎ ಡ್ಯಾಮ್ which is not permitted by the tribunal, which is not permitted by the judgment of this court. Therefore, direct them, stop them. So it is sort of a direction to implement the judgment of the Supreme Court by stopping Karnataka.
Okay.
Plea.
Okay.
We have pointed out that where is the restriction in the whole judgment or the tribunal against Karnataka. Once I give 177.25 teams in normal year or proportionate share in the bad year, matter ends. Anything extra, it is to my benefit. There is a surplus water available, and here in this dam, I'm not taking all surplus water. I'm only taking a little surplus of 13, that too for his benefit, to help him in the bad year. Otherwise, my benefits are only to generate power. Even drinking water of Bangalore, which I get, that is only to stabilize, not that additionally I get. I already got whatever I have to get in the Supreme Court judgment. So this is what we have told. Let us see how it goes. There is also a suit filed by Karnataka saying that I have right to surplus water, and all surplus water, which were estimated around 80 TMC, I think, should be declared as my right. And so all these issues are together. The court will have to decide.
ಯಾವಾಗ ಇದು ಬರುತ್ತೆ ಸರ್?
Well, very difficult to say. And also there are a lot of legal problems. They may say that, well, this is all water dispute, the fresh water dispute, go to the tribunal. Well, that happens, it is very bad. Because with Krishna, it did happen. When we asked for implementation of the scheme B, surplus water, the Supreme Court in 2000 said, sorry, we can't do it. 25 years elapsed. It is a matter which has to be freshly looked into by this new tribunal. If you want to file a complaint, you file. So we filed a complaint, a fresh tribunal was constituted, then we succeeded in getting. But against that, there is a judgment appeal pending in Supreme Court. That's okay. So second tribunal process started. I hope it won't happen here.
Okay.
It shouldn't happen.
Okay.
But one doesn't know.
ಕಾವೇರಿ ವಿವಾದ Is it a perpetual issue?
There is a saying in America that all water disputes, there is nothing like a resolution of water dispute, only management of the water dispute.
Okay.
For instance, if we take river Arkansas in America, between the Colorado and the Colorado and Kansas, two states have been litigating for the last 120 years. There are 5 rounds of litigation in the Supreme Court. Right. Any other dispute you take in America, they always come back to the court. In fact, in American Supreme Court, whenever they pass a decree, they have a clause at the foot of the decree. That is, in the changed circumstances, parties can apply for modification of the decree. So, in the changed circumstances, a particular decision after 25 years becomes unworkable.
Okay.
New facts come in. So if parties can solve bilaterally, great. If they can't solve, again they knock the doors of the court. So that way the litigation goes on. But we'll have to keep it under the control as far as possible. Otherwise, sometimes things go out of hand. In Kaveri, I must say, it is largely resolved as far as the main dispute is concerned. 740 has been distributed. Only this surplus issue and distress issue are causing a problem. With regard to the main dispute, maybe after 25 years, if the figures change, if we're able to show that the water has increased from 740 to 780, or somebody shows it is less, then reworking of the share comes in. Or if you're able to show that the Tamil Nadu doesn't require so much of water which they got as existing irrigation, now with the help of a better scientific cropping system, they can use less water and grow, then they don't require that kind of a protection. So all these issues may come back again, and I only hope that it gets resolved at the ಗೌರ್ಮೆಂಟ್ ಲೆವೆಲ್. ಎರಡು ಗೌರ್ಮೆಂಟು ತಾವು ಕೂತ್ಕೊಂಡು, ಆಮೇಲೆ ಫಾರ್ಮರ್ಸ್ ಕೂತ್ಕೊಂಡು, ಸಿವಿಲ್ ಸೊಸೈಟಿ ಕೂತ್ಕೊಂಡು ಅವರೇ ಸಾಲ್ವ್ ಮಾಡಿದರೆ ಒಳ್ಳೆಯದು. ಮಾಡ್ಲಿಕ್ಕೆ ಅಂತಂದ್ರೆ ಅದು ಕೋರ್ಟಿಗೆ ಬರ್ತದೆ. Then both the sides have to break their heads, engineers and lawyers sitting together.
Thank you, sir. Thank you very much for your time.
Pleasure.
Yeah. Namaskara.